Welcome to the Board of Equalization. You'll have 10 minutes to make your presentation. We'd ask that you commence with your introduction for the record. Good to see you again.
Good to see you, Chairman Horton. I want to thank you and the rest of the members for hearing this case. My name is Graham Hoad. I'm president of Sales Tax Resource Group. My client on my left is Mr. Philip Anaker. He is the founder and managing partner of Flying Goat Coffee. Flying Goat Coffee has two locations at issue. One is in Healdsburg, California, and the other is in Santa Rosa, California. The audit of these locations was conducted for the period of July 1st, 2007 to June 30th of 2010 and resulted in an underreported taxable sales of approximately $489,000. We've been working with the audit staff, with the appeals division, and with the settlement section, and we still have not been able to resolve many of the issues and the questions regarding why the department believes that the petitioner underreported taxable sales, and this is why we're here, and we're really hopeful that we can achieve a fair resolution of this matter through the board hearing process. First, it's important to note that Flying Goat Coffee staff at the coffee shop always asks and always has asked whether the beverage purchased is for here or to go, and they ring the beverage up accordingly. This fact has not been disputed by the department, and it impacts pretty heavily the way the department conducted this audit. So they always ask and they always have asked. Prior to this audit, the department audited Flying Goat Coffee for the period of fourth quarter 2003 to fourth quarter 2006. And in that prior audit, the department accepted reported taxable sales percentage for the period for a prior period even before that. They took the prior period taxable sales percentage for fourth quarter 2001 through third quarter 2002 based on observations of the business and applied that percentage to what is now the prior audit period. That taxable percentage was 11.51 and it was 11.51%, and that was reviewed and accepted by the department. The department now states in the DNR, in the decision and recommendation, that they expect a taxable sales ratio of 30 to 40% for this type of business, and they reject Flying Goat Coffee's reported taxable sales percentage of approximately 11%. So our first question is, why would the department accept a taxable sales ratio of approximately 11% in the prior audit, but expect a taxable sales ratio of 30 to 40% in the current audit? In other words, why would they deem 11% acceptable then, but not acceptable now? The DNR also states that the department observed Flying Goat Coffee staff erroneously ringing up sales of soda as non-taxable sales to go, as well as ringing up sales of coffee served in the customer's own cup as non-taxable sales to go. And great weight was given to these random observations, which led the department to believe the taxable sales were understated and to impeach Flying Goat Coffee's records and to conduct the full-blown observation tests on the business. However, there's no mention in either the 414Z, which I'll note was 12 pages long, or the audit working papers, both of which had very detailed notes, that the auditor had observed sales of sodas prior to performing the observation test. The only mention in the 414Z of any random observations were that the auditor noted that there were tables and chairs outside the 419, which is a different location, and the Santa Rosa locations. As the DNR suggests, if the observations of the soda sales occurred before the observation tests, why were these random observations not documented in the 414Z or anywhere in the audit working papers? Also, during the 4 days of observation, the taxpayer only sold and erroneously rang up 1 can of soda. Other sales of carbonated beverages, although immaterial, were properly taxed. Regarding the sale of coffee in customers' own mugs, own travel mugs, which the department cites as evidence that taxable sales are underreported, even if a barista did not ask whether the sale was for here or to go, a reasonable person, we believe, would conclude that a customer purchasing coffee in their own travel mug was doing so for the purpose of consuming the beverage off-site. And this is not evidence of underreported taxable sales. And so the department places great weight on the random observations of soda and coffee consumed in the customer's own mugs in support of their position, and yet it appears that either these events never occurred or they're otherwise irrelevant. During the appeals conference, it came to light that the department did not perform the observation tests in accordance with board policy. Now, many years ago, the board grappled with the issue of whether an ice cream cone was consumed for here or to go in what we affectionately used to refer to, back when I was an auditor, as the lick and leave dilemma. That is, if a customer takes a lick of an ice cream cone before walking out the door, is that a taxable sale for here or an exempt sale to go? And the board correctly decided that the retailer should not be put in the position of being the tax police and be required to chase down the sales tax from any customer who took a lick before walking out the door. The department still applies that methodology today, and I'll explain a little bit later. In this case, the department conducted the observation tests by recording whether the customer sat down or whether they left. When it was argued that the observation test should have been conducted by recording whether the customer stated the order was for here or to go, rather than what they actually did, the department accepted the recorded amounts for the observation tests, which were based on what the customer said and not what the customer did. Now, prior to making this adjustment, their observation tests erroneously resulted in 30 to 40% taxable percentage. Now, there are two problems here. First, the department expected taxable sales to be 30 to 40% of total sales based on audits of similar establishments. However, this expectation was only documented after the observation tests had been performed. So it's coincidental at best that what they expected from the audits of similar establishments is exactly what they achieved in the observation tests. Second, when they claim that they expect a taxable percentage of 30 to 40% for this type of business, it's because they're recording what the taxpayer did, not what the customer said they were going to do. How does the department justify citing audits of similar establishments as evidence that Fly and Go Coffee underreported taxable sales when strong evidence suggests that they have not been conducting the audits properly for what they claim in the decision and recommendation is over a decade? The department conducted the two observation tests per location and performed a litmus test. They compared the results of those tests with 6 months of recorded sales, and for these 6 months they computed the range of taxable percentage that was recorded in Fly and Go Coffee's point-of-sale system. One observation test in each location fell within the 6-month range, and one observation test fell within 2% of the upper limit of the 6-month range. So here's the 6-month range. One test fell right in the middle, one test fell right near the top. Rather than accepting the taxpayer's reported sales percentage of 11% because the taxpayer passed the litmus test, the department averaged the observation test results, resulting in 21% and 23% taxable, and applied those results to reported total sales for the entire audit period when they had absolutely no basis for doing so. The department keeps reminding us that they saw people sitting in the coffee shop at all hours of the day, and that's why they don't believe the taxpayer's records. Keep in mind that if 100 people walk into a coffee shop and those 100 people order their coffee to go, and those 100 people sit down in the coffee shop, those 100 orders are exempt. There's no nexus between the number of people sitting in the coffee shop and how people order their coffee. This is why it's so important to remember that Fly and Go Coffee always asks whether the coffee is for here or to go. Yet the department will tell you that it's improbable that on some days 98% of the customers stated the purchase of coffee was to go. They'll tell you that it is statistically impossible, particularly when they randomly passed by the shop and saw people sitting at tables at all hours of the day. But they also told us that they observed sodas being sold on a to-go basis, but there's no record of it. They also told us that they were doing the observation tests properly, but we know that they weren't. They told us that coffee served in travel mugs was taxable. We know that it's not. And they told us that they expect 30 to 40% taxable for this type of establishment. Yet, those tests were based on incorrect observations. Today, people are savvy and they want flexibility. They want to be able to decide later on whether to stay or to go, and most people order their coffee to go for that reason. The department has provided absolutely no evidence that the taxpayer did not ring up the order as the customer indicated, nor that taxable sales was not properly reported in accordance with Regulation 1603, as well as board policy. Fly and Go Coffee is doing everything they can to comply with the sales tax laws, and yet the department continues to hold them responsible as the tax police. For these reasons, we respectfully request that the petition be granted in favor of Fly and Go Coffee. I just want to follow up. Do I have any time? Okay, sorry, but that took over 10 minutes. I apologize. I have a letter, and I provided this to the board staff. It's a letter from the auditor, Charlie Witten, to Ramona Varega, who was the appeals officer at the time. And we talked about the lick and leave test, and we talked about that the tax is only due on orders where the customer states that the order is for here, not if they state it's to go, even if they sit down. In this letter, I'm going to quote it directly. The department has historically, presumably meaning the past decade that they refer to, the department has historically held that taxpayers are responsible for tax on all food products consumed on the premise, regardless of what the customer has indicated their intentions are. We have encouraged retailers to collect tax reimbursement from customers who indicate that they will consume the cold food products on the premise, but report on a percentage basis above the sales that they have collected tax on to capture the sales where customers have indicated the order is to go, but then have consumed the items on the premise. So this is what the auditor told to the hearing officer, that we are taxing we want the taxpayer to report tax if the taxpayer or the customer indicates it's for here, but also report additional tax if the customer indicates it's to go but sits in the coffee shop. And this is why we think this audit has gone terribly sideways.
Thank you very much. Members, let us go to the department. The department has 10 minutes to make their presentation. We'd ask that you commence with your introduction for the record.
Good afternoon, Chairman Horton and members. My name is Scott Lambert, and I'll be representing the Sales and Use Tax Department today. To my right is Kevin Hanks, also with the Sales and Use Tax Department, and to Mr. Hanks' right is Robert Tucker with the Legal Department. Oh, I'm sorry.
Pardon, wrong.
That was Steve Smith. Yeah, I've done that before. But anyway, to start off, what I'll say is that whatever the auditor believed at the time of the audit, there are no sales where there was any indication that the tax or the customer could have left the premises and that item was included as taxable. So originally, when we conducted the audit, the auditor was inside the business. One was inside, one was outside, and what they saw was people getting coffee in ceramic or porcelain cups and sitting down, and they also saw customers getting paper cups and sitting down. And there was also customers with their own travel mugs, or and I don't know if they were travel mugs. What I'll say is it's referred to as cups. So the taxpayers own cups, and they may have been travel mugs. But anytime those were considered taxable is when the customer sat down. So the fact that you had a travel mug in and of itself, we didn't say, oh, that's taxable, or you left with that. It was only the people that sat down. After the audit was conducted and it went to the supervisor and the DPA, they all concurred that the auditor did not hear what the customer said, did not hear what the employee asked, and all those sales that were in question were removed from the audit. So that is not at issue here. There was a prior audit, and approximately the taxable sales came out to about 11.5%. The current reporting taxable is about 11%. What I'll point out, in the prior audit, there were some recording errors based on the POS. Those were corrected. The taxpayer was instructed the proper way to report, and there was no observation test. So the auditor did not sit there and watch how many people were sitting down. The auditor states that there were options given to the taxpayer, and they declined to have an observation test, and that is what they recall from here. There is an entry on the 414Z which says the taxpayer was given options in the prior audit, and the auditor at the time says that was one of the options. They didn't want to do it. He didn't force them. Well, he can't force them, but he didn't pursue that, and he accepted what they had claimed, which was 11.5%. In this particular audit, when the auditor was in, they noticed a large number of people that were sitting down. And that is supported by the observation tests. If you look at the observation tests for each one of them, and there's two different locations, Healdsburg and Santa Rosa. One is in the 30% range, 30 to 40%, and the other one was 30 and then a little over 40%. So there are a number of customers that are sitting down here. And just to point out again, we didn't include any where there's a possibility that they could have said to go and they sat down. Now, the department doesn't agree that whether the taxpayer always asked whether to go or not. We have no idea what was stated. What I'll point out is that the taxpayer does not charge tax on their coffee sales. So when somebody comes in and gets a coffee, they would get charged a price, and there's a key ring that's hit on the register, and that records whether the taxpayer is going to report that as taxable or not. So if they don't hit that key ring, it doesn't report as taxable. So when we look at the 6 months for that, the test, or not, I wouldn't say a test, I'd say we analyzed the data for 6 months at each one of the locations. The number of sales that were less than 10% at the Santa Rosa location is 58% of sales, or less than 10% at Santa Rosa. For Healdsburg, it's 37%. So there's a number of days where there's a low percentage. We have no idea whether that register was hit the button for whether they were staying here or not. What I'll say is on these two tests, there were 2 days tested. We did not test for a complete day. We should have. We have offered to accept the taxpayer's recorded records for those 2 days to use whatever that taxable sales were for the percentages for those 2 days. We're not opposed to that. As the representative said, that we did notice one error. Otherwise, we're accepting what they were recording for those particular days. We've also offered to conduct additional tests. We offered to conduct additional tests during the audit. The taxpayer declined for us to conduct additional tests, and I don't know if they decline now for us to go out there, but that's the offer, that we're not opposed to going back out and seeing or doing more testing for this. But in each one of these, there's 2 days tested for each location. The taxable sales on one of the tests is more on both locations than they had reported as taxable in the 6 month periods that we looked at. And the other one was at the upper end of those percentages. So the odds are that we're going to test 4 days, and there's going to be 2 days that just during our test that happen to be higher than any taxable percentage they have. Was right. Statistically, it's improbable that that is going to take place. The calculation is going to be less than 1%, and in some cases in the 10th percent, that could happen at each individual location, let alone both locations together. What the taxpayer has reported at this particular time is basically 4 customers per hour sitting down at their location, and the department believes that number is higher based on the observation tests that we conducted, and that's the net result from those. We have 81 at one of the locations for both days, and at the other one, we had 62 and 69% or numbers of people that were sitting down. So there are a number of people as supported by the Yelp comments and just the knowledge of staff regarding that particular business in general. So accordingly, the department concurs with the Appeals Division decision and recommendation.
Thank you very much. Members will now provide an opportunity to rebut at your convenience.
Okay. The department just told you that there was a prior audit and no observation of the business was performed because the taxpayer declined to allow the observation. The 414 for the prior audit states that on 4/4/2007, the auditor observed the business activity. On 4/10/2007, he observed the business activity. On 4/11/2007, he observed the business activity. I don't see anything in here that states that they declined to allow the auditor to do an observation test. I don't see that there. I don't know why that statement is in the department's analysis. Second, he said that not all parties agree that the taxpayer asked that the customers asked the customers whether the orders were for here or to go. In the letter to Ramona Varega that I just quoted from, it states, quote, "All parties agree that the taxpayer's employees have asked the customers whether the order is for here or to go." It doesn't get any clearer than that. Third, the department, in order to go to an indirect method when they do an audit, they have to first impeach the taxpayer's records in order to move to an indirect method such as an observation test. They use as, let me see, hold on just one second here. The reasons that they use to impeach the records are that, let's see, they say that we find the department was justified in impeaching petitioner's records because the department observed several instances in which the petitioner's employees erroneously rang up taxable sales of soda to go as exempt, or taxable for here sales of coffee as exempt. Again, we go to this, here's the 414 for the prior audit. This is the 414 for the current audit. It's 12 pages long. He's got incredible amounts of notes in here, but nothing about he went in before those observation tests and saw anything about a sale of a soda, that he saw sales of travel mugs. This was all brought up after the fact in this letter from Charlie to Ramona is the first time in 2013 that statement was ever written. And so I don't think that they ever had any reason in the first place to impeach the records of the department. Fourth, viewing people sitting in a coffee shop does not a for here sale make. It all hinges on whether the customer walks into the coffee shop and states that the order is to go or for here. That's what determines the taxability. Nothing else. To say that, well, we still believe because we saw people sitting at the tables that the taxable sales was understated. That makes there's no nexus to that. There's no connection between those two events. And finally, he says, well, the knowledge of the department staff is, such that we expect a 30 to 40%. I already pointed out that the staff is doing it wrong. They didn't know how to do it, so they were doing it wrong. So their knowledge was not there. It's interesting to note that when they did the original observation test, they expected 30 to 40%. And when they did their incorrect observation test, they got 30 to 40%. When they had to make the adjustment to accept the taxpayer's records, they got between 20 to 30%. And lo and behold, in the decision recommendation, the appeals officer writes, however, we would expect taxable sales of a ratio of 20 to 30% based on the coffee shop's substantial indoor and outdoor seating facility. Coincidental, I think. I don't know. I mean, it seems like they're just trying to justify whatever they found in the observation test, and I don't think it's fair, and I think they've been, like I said, I think they've been used as the tax police to try and get these they're trying to justify that the taxable sales are understated. I'm done.
Thank you very much. Discussion member Harkey.
I'll go first. For the department, Scott, I believe that you said that you would be willing, says the auditor, or I know the auditor is no longer with the board to confirm, but staff indicates the auditor believed that most coffee sales took place during the first part of the day. Do you concur with that?
Yes.
Okay. So when we did our audit, when we did our observation test, did we use a half a day in the morning?
We took the date, I'll get the exact, the one observation test was from 7 a.m. to 2, well, let me get for, it's Santa Rosa, 7 a.m. to 2 p.m. The next day was 7 a.m. to 3 p.m. For the Healdsburg location, it was 7 a.m. to 4 p.m., and the next day was 7 a.m. to 3 p.m. So that's pretty much in the morning through most of the day. There's a couple hours left at the end of the day that we did not cover.
Okay, and what were, you said something about using the rate, the taxable sales rate for the 2 days, the on-site audit. What, or the observation audit, what were the taxable sales ratios for those 2 days?
Well, for each one of the locations, first, the Santa Rosa, there was 2 days, August 31st of 2010, it was, and do you want rounded numbers or?
Yeah, that's fine.
Okay, 24% for that day. For 3/3/11, it was 19%. The average was 21%. For the Healdsburg location, the first day was 10/05/10. It was 20%. The next day was March 2nd, 2011. It was 28%. And the average there was just a little over 23.5%.
Okay. Yeah, I see. Okay, I see where you're going with that. I don't know why that was brought up, because that looks like that's the number you're using. I thought maybe there was some wiggle room in that. Okay. I think you stated that prior to the observation audit that the auditors did not observe whether the sales were asked for, or whether the customers were asked for here to go.
That I don't know
Okay.
whether they were we don't dispute that. Our position is what the representative stated, that during all 4 of those test days, that the position is that each one of those customers was asked whether it was here to go. My statement was for the audit period, we have no idea if each one of the customers was asked whether it was here to go. But there's no question that the way the audit is conducted, that's how it was treated. The taxpayer said that, and only the customers that sat down with a returnable container were included as taxable.
Okay. With the exception of the one soda, did the department observe any key ring errors during the observation test at all?
Well, what I would say is the ultimate result is no. What I would point out, and is just the difference between the two, because originally we thought we had, because we saw the number of people that sat down was on, and this is for the Santa Rosa location. For the first day, we saw 108 sit down, but we ultimately only included 81 as taxable. On the second day, we saw 113 sit down. We only included 81 as taxable. And for the Healdsburg location, on the first day, we saw 93 sit down. We only included 62. The next day, we saw 105 sit down, and we only included 69.
And
So-
how was that arrived?
Well, because what happened is the auditor was not close enough to hear what the employee asked or what the customer responded, and that those people that sat down had paper cups. And so the assumption was made that those customers had said to go and then sat down. So your question is did we have any ring-up errors? The way the audit is done right now, I would say no, but I couldn't tell you whether there were ring-up errors or not, because we don't know if all those customers said to go or for here, and then it wasn't taxed because they got a paper cup. But really,
Wouldn't
that's
that show up on the cash register? I mean,
they didn't record it up. They didn't record any of the customers that sat down with a paper cup as taxable.
And that was verified with the
By the
observation
auditor.
test?
Well, that's right.
On the days of the observation test,
Yes.
or no? Yeah,
On
okay.
that day, so that's really not.
So these numbers, though, the 21 and the 23 and a half and averages are partial day.
They are for a partial day. They don't
Right.
include the last couple
7
hours.
to 3, right.
Right.
And
May I say something? They aren't for a partial day because they ended up using the taxpayers' records for those days. Unless I'm wrong, I believe
Well,
that
an
I believe that we use the taxpayers' records for those days. The observed were 37% and 33%, but we use the taxpayers' records to develop the taxable percentages of 23.5 and 21.3 for that entire day.
That's not correct.
That's not correct? Okay.
That's not correct. We
Okay.
use the
Sorry.
taxpayers.
Member
if I
Harkey?
could-
I'm
well, you can
sorry,
ask
go
me.
ahead, yes.
What it means by we use the taxpayers' records is that up through that time period, we use
Okay.
the records that they had through those hours. So we didn't
My mistake,
use the
excuse me.
last couple of hours for there.
Okay.
So we pretty much accepted how they rang up the sales for those days, except for the one carbonated beverage.
Okay, next question is, the prior audits assessed the tax at 11.5 and 11%. Why are you considering those ratios too low? Strictly on the observation, or?
That's right.
And the assumption that these were taxed, or you're saying that the observation, though, was checked back to the cash register tapes
For the prior audit?
for the taxable and non-taxable?
Well, in the prior audit, we pretty much accepted how they rang up the sales, and there was no observation test. So I believe your question is like, why would we do that?
Okay.
I think there was, from the auditor standpoint, he was an experienced auditor, but my understanding is he wasn't experienced in that type of retail business, and he probably accepted that when he shouldn't have. And I think the other thing is that he advised them how to report correctly, and he thought that would take care of the issue, and then he didn't think there was a materiality issue with it, and that's why he ultimately accepted it, is my understanding.
Okay. I'm sorry. Inside joke. Okay, so for the taxpayer, is there any reason that an observation test conducted today, not that I wish to put you under that, would produce a different result than?
The only thing that I can think of is that they've added Wi-Fi to the business, and so, and maybe Phil can expand on this, but I understand that they've added Wi-Fi. So the people who sit down in the restaurant and stay there and order the coffee to go might have increased. And I understand, I haven't looked at the subsequent periods as far as what the percentage of taxable sales that were reported afterwards, but I understand based on my discussion with Mara Harrington, who's the co-partner, I understand that when they did add Wi-Fi, the taxable sales percentages did increase.
Okay, so you're,
Yeah, I don't think you would be comparing apples to apples if we did an observation test today versus
Versus what was before?
Yeah,
Okay, that was
5 years ago.
kind of my understanding. For appeals, why didn't you question the department's failure to perform observation tests all day, entire days, as recommended by the audit manual?
At the time, it was recommended by the audit manual, but at the time that the DNR was issued, that was not an absolute requirement.
Okay.
And the DNR author understood that the petitioner was not open to longer testing, which I understand is not the case.
Do you know why, what changed since, well, I guess we've kind of answered this, but not really. Prior taxable sales were 11.5 and then 11%, and that's what the customer is, or the taxpayer is claiming is more in line with what they were doing at that time, although not now, because they have Wi-Fi and people are actually, plugging in and sitting around. Why didn't appeals ask the department what changed so that you would expect a taxable sales ratio of like 30%?
To our knowledge, nothing changed. It was simply the way the audit was done, and the prior audit was not raised and was apparently not looked at. Perhaps it should have been. However, the department isn't required to maintain the same. They're not required to say it was 11% here, so we're just going to accept 11%.
No, but I think that would raise an issue. You'd want to know, if you got 11 to 5, then you're going to 30 to 40, and then adjusting down to 21, 23, what changed in that period? So I'm just questioning how, because we don't have the auditor anymore, and I think that the staff is doing its best, but it just seems like we're, what other options, excuse me, this is for the department, and I probably should know this, but I don't, so I'm going to ask it. What other options, other than having someone say, for here to go, does a coffee shop have?
As far as reporting?
As far as recording taxable versus non-taxable?
Well, that's pretty much it.
And
to
it
know
sounds
whether
like they
they're gonna
did that, yeah.
Right. I mean, you could have, I mean, based on a cup, you would, I mean, if you weren't asking, it would, if somebody's getting a porcelain cup, it's probably for there, I would think. I mean, I
Well,
guess you
if
could have some
it's
people.
provided by the facility, yeah.
Yeah, I guess you could
See,
have some
I bring my
walking
own
off.
porcelain cups too, because I don't like paper.
Right. Well, they have porcelain cup here because they're a green
So if they're selling with a
company.
porcelain cup, you kind of know that's here.
Well, you would
That's
think,
for here.
you would
Right.
think so, unless there are people walking off with them.
Right, if they're
Um,
stealing your goods.
but you could
Okay,
have-
I'll just one more question for the taxpayer. When you rang up the porcelain cups, did you ring those up to go or to stay? Since that seems to be a,
To stay. Realize too that if we make a mistake, we have to make the drink again.
okay.
So if we give someone who wanted it to go, if we give it to them in a porcelain cup, most of the time they're going to make us redo it, so we lose the product. So
Okay.
our staff has to be accurate every time, and they're well-trained. I mean, this
Okay.
is,
I feel like the problem centers around what other options do you have other than to ask for here to go? And you have a cup, maybe a positioning of a cup, but just because people come in and sit down, you don't really have an option at that point to go back and say, hey, you're sitting, I want to tax you, I need to pay tax. So I'll just let it go, I'll let somebody else.
Member
Thank
Ma.
you.
Okay, thank you. I had a question about the soda. How many sodas did you observe?
There, I don't know off the top of my head the exact number. It was a handful, a couple handfuls, something to that, in that area
Okay,
during the test.
okay. Oh, and talking about the test, what is the usual procedure? I thought it was supposed to be 3 days. for site tests?
Right. Well, it depends on what kind of test you're doing. The rules have become more defined now. They weren't as defined then. It recommended that you do a complete day, but that was not a complete requirement. It was said if you could do it, you should do a complete day. But in my opinion, we should have conducted the test for a complete day.
Just one complete day, two
No,
complete
I
days,
would say a
three
number
complete
of,
days?
I think when you take a look at that, at what happened in this test, in that there was, at the end of this, there was a dispute as to, did you ask to go or whether it was for here? And ultimately, we agreed with the taxpayer and took those out. We would want to test again because now we would actually want to hear what those people with the paper cups actually said. And because there might be the circumstance where someone wants to just drink a portion of their coffee and then leave with that paper cup. So for us, it would be to our best interest to further that test. And as I mentioned, the taxpayer declined for us to conduct further testing. So at that point, we really couldn't correct the partial days that we had initially observed.
So to the department, I want to verify if there is a large coffee chain in this industry that has a certain percentage taxable sales.
Right. Well, there's probably a couple of them.
One in
And what is the?
I'm
what is
familiar
the,
with some of them.
Okay, well, what is the percentage that they are allowed to use?
You know, I'm not, allowed to use?
Or whatever they report, and then I guess the
Yeah, I
department
know.
verifies whether the
Yeah.
percentage is higher or lower
Right.
each year, but they, as I understand, they're allowed to use a certain
Mr.
percent.
Hanks.
They don't have to charge tax on everything or ask to go or to stay. They just pay it at the end of the year. Is that
Ms.
true or
Ma,
not?
I would just add, that I'm not familiar with the arrangement that you're talking about, but what that taxable reporting ratio is would probably be confidential information, so we probably couldn't discuss that here. But I would think that it varies. It probably varies, well, absolutely, it varies by location. So depending on the size of the establishment, just the number of people that might take their beverages to go, whether or not they serve food there. I mean, some of these places that we're thinking of are smaller.
I'm not asking
bigger.
about that. I'm just asking because I think a lot of the smaller coffee shops that are similar to these large chains, you know, are facing higher percentage taxable sales than these other large chains, which have an agreement with the BOE that they can report. They don't have to collect, but they just pay it at the end of the year at a certain percentage. And that's what I'm trying to figure out, because as you can see, I mean, it's very confusing having an auditor sit inside, outside, trying to figure out, you know, to-go cup, styrofoam cup, you know, porcelain cup. Yet
just
why
sounds
aren't they
ludicrous.
able to use, you know, have that same sort of, you know, methodology that some of these larger chains,
Right.
you know, why can't they just pay at the end of the year a certain percentage, and then you guys can come and audit and verify versus, you know, this 2-day tests, 1-day tests, and then just trying to, you know, say it's 40% taxable sales.
Right. Ms. Ma, what you're saying would be workable if the taxpayer were to elect to do something like that, and there were observation tests that they'd conducted to determine what that percentage was, and we could verify those amounts. I don't think that we'd be in disagreement with looking at that information. I think in this case, the auditor, the audit staff that looked at the assignment thought that just based on their knowledge of that business, that the 10% or 11% reported taxable sales looked low for that establishment and based on their own personal knowledge of that business.
Okay, but you're open to allowing smaller mom-and-pop coffee shops to work on a prospective level in terms of the taxable sales or the taxes, sales tax that they want or will report to collect, and then you would audit to verify, similar to these large retail establishments.
See, I'm not familiar with the arrangement that we have with the larger retail establishments, so I couldn't speak to that. I could just speak to whether or not the taxpayer put together a test of their own. If those amounts could be traced and verified by the audit staff, and it looked reasonable based on their knowledge of that business, then yes, I think that would be agreeable with the audit staff.
That's all the questions I have for now.
Thank you, Member Ma. Member Rutner?
Yeah, let me just.
A couple of things. I'm also aware of arrangements that we've made with larger coffee folks, and I guess I'm kind of stunned that some of the staff executive staff at that point are not aware of it. I guess that's a little stunning to me, but that's another issue. And I'm just wondering why, in that sense, in a situation like that, that whatever that amount is, that isn't then at least some kind of a standard that could be applied when there's dispute. And so that's my observation there. But I'll tell you, the question I actually want to talk a little bit about is in the letter. Help me understand the letter of December 23rd that was read. And again, I'm just wanting to get some context to this because I'm afraid I'm trying to figure out if this is flavoring the attitude of the auditor, where it says the department has historically held that taxpayers are responsible for tax on all food products consumed on the premises, regardless of what the consumer has indicated their intentions are. Is that
What's the year on the, I'm unfamiliar with.
2013?
2013. I would say at that particular point, that was not the department's policy.
And then
So-
it goes on to say, we have encouraged retailers to collect tax reimbursements from customers who indicate that they will consume the food product on the premises. That's not the policy.
That is not the policy. The policy is if someone says it's to go, that it's not included as taxable in the audit, or nor is the taxpayer responsible for reporting that tax.
But to report on the percentage basis above that sales that have been collected on tax to capture the sales where customers have indicated the order is to go, but then consume the items on the premises. So that would be all incorrect.
Correct? That's correct.
Is this letter from the auditor?
To the appeals officer.
Is there any history of correction on this? The two appeals?
I have, that's the first I've heard of that letter, but I know there, in the olden
Where did
days,
this- okay,
we
hang on.
did do it that way.
Okay, let me ask, where did this,
But-
I'm not sure where this letter came from. Was it in the file? Was it, I mean,
This-
I got a copy of it, so
Yeah.
I assume it was in the file.
Yeah, this letter is in response to our letter to the appeals officer, our brief that was given to the appeals officer at the appeals conference, and they responded to our brief, and this
So
letter.
this letter can be found in the file?
Yes.
So
This is where I
have
got
you
it.
not found this letter
I
in the
have
file?
not read that specific
And you have not
letter.
found this letter in the file?
I don't recall reading it. It may be in the file. What I would
Would you like to see the letter? Have you seen the letter?
If I read it, I might recall seeing it.
Maybe I think you've got a copy of it. Maybe we can give that to both appeals and
We'll give it to
they'll
What
make a copy of it.
What I would say is that the conference holder did not follow that in any way.
Yeah, I tell you, I get that and I understand that, but what I'm trying to get through is I think this tells me of a bias. This would indicate a bias to me of the auditor in regards to how they did their work. And I guess it was really concerning to me if this is a letter that was done and then to the appeals office and there's no correction in it. That sounds like there's no reason to assume that this isn't current policy then.
Right.
And I, for one, would be appalled if our current policies or the intentions of policies out there by auditors is the fact that we would be asking them to ring up on taxpayers taxable sales when the taxpayer said, the taxpayer being the consumer, excuse me, the consumer said to them, I'm going to eat this. This is to go. I mean, that to me is almost fraudulent on the part of, we're asking them to overtax somebody. So I don't know. I'm a bit concerned. Like I said, I'm more concerned about what this tells me about the attitude of the auditor in this setting. I'm sorry, was Appeals going to say something?
I was just going to say, I think that has to do with the lick and leave. The department did a long time ago do it the way that says, but it's been changed for several years.
Yeah. Okay. Let me ask you again. Let me see about the business a little bit. Yeah, coffee business. You sell other kinds of things there. What kind of things do you sell besides your coffee?
Teas, some pastries, very little soda to go. It's really mostly about coffee.
Very similar to what I would find in one of those big retail chain coffee shops.
Close, yeah.
Coffee
But
company,
the coffe's
I just-
better.
Huh?
But the coffee's better.
I'm sorry,
At
the
our,
what?
the coffee's better at our place.
Well, I just, of course. Of course, let's do.
Thank you.
Yeah, for people getting this, the statement is in the middle of the second paragraph is where the statement is. Okay, so very similar to those larger chain issues. Your seating, how many seats do you have?
In one store, I would say it's probably about 35 seats.
Okay.
And then in the other one, it's probably half that. The Santa
Okay.
Rosa store, it's about half that.
Okay, thank you.
Just from an administrative perspective, I just thank you, Mr. Renner, for providing letters of advice that go out from the Board of Equalization and incorporates the names of the members, should go out on the letterhead that does not have the members' names on it. So if you guys can correct that in the future so that the member's name is not on these letters of advice, that'd be much appreciated.
Yeah, especially when the advice is bad.
To the department, can you give us the results of the observation test, the numbers that you observed and the numbers that you actually allowed?
Okay, I'm sorry. The two sets of, for each location.
For each location, you had indicated that you observed 116 set down. I just didn't write the numbers down.
Oh, okay.
And then you allowed,
Right. Okay, so for the Santa Rosa location, the auditor, on August 31st of 2010, the auditor observed 108 taxable transactions.
taxable meaning,
They sat down, or they bought something that was taxable.
okay.
And then what was allowed, or what was used in the audit was 81 transactions.
And why did you use 81 instead of the 108 that was observed?
Because the auditor did not hear the conversation between the customer and the employee as to whether it was for here or to go. And all of the 27 that were allowed were either paper cups or the customer's own container.
Okay.
All right. And so for March 3rd, 2011,
So in other words, you really didn't follow the lick and go
we did not.
policy? Okay.
Well, we originally did, and the results that stand today, no. It's not included in there. It's only the customers that had returnable containers, a porcelain cup, or a taxable product such as a carbonated beverage.
Okay.
Chairman Horton?
I'll come back. I've conducted audits on some of the larger chains, and what we may be thinking of is the managed audit concept, where you have all of these different chain operations, and they do different things, they're in different locations, and so we kind of average it all and come up with an average, allow the taxpayer to go in and do their computation. It's kind of like, you know, the managed audit concept. Are you familiar with that? And how does that work in these situations when you have multiple chains and they allow them to do a managed audit?
So a managed audit would work very much like you're describing, where there's an area of the audit that the auditor wishes to verify, but for the sake of saving time on the taxpayer's part as well as the department staff, we allow the taxpayer to conduct that review and that analysis of that area of the audit. Generally, it's an area that both parties agree that should be examined. We enter into a little contract with the taxpayer, just identifying what those expectations are, what areas are going to be examined, the time frame in which that is conducted. So perhaps that's what Ms. Ma was speaking about.
I think Ms. Ma has a legitimate point, though, and maybe we ought to take that up in the Business Tax Committee. When we have that data, we should at least provide, and we don't have sufficient data. It's always best to look at the audit on an actual basis whenever you can, and certainly not use additional data out there, but providing the taxpayer the option of having that same convenience might eliminate some of the heartburn that we experience in these cases. So I would suggest that we consider that in the Business Tax Committee and seeing if we can come up with a safe harbor rule. If appropriate for the industry. The challenge with what we do here, it's always a double-edged sword. We do one thing, it affects another 100 people, you know, differently, which is the inherent nature of taxation in and of itself. All right.
I just have one quick question.
Ms. Member Stowar.
Okay, just real quick. So you were giving Chairman the count of 108 taxable transactions, but you only used 81. And basically saying you didn't apply that lick and leave policy, and acknowledging that the auditor couldn't hear what the customer was saying. Why is that? Was the auditor near the cash register? Was the auditor?
I'm not sure. The auditor was far enough away, but inside the establishment where they could see the transaction, but they couldn't hear the conversation. There was also an auditor that was located outside that was also observing.
Is that normal policy where you could only see but not hear?
It shouldn't be. You really need to hear the conversation because you need to know what the customer's saying, because that's how you're going to find the errors for, you know, and you don't usually find, you know, out of 108 to 81, you usually don't find that many customers that say to go and then sit down. This, you know, whether people do it on purpose or not, in this particular case, it might be the situation where maybe they thought they were going to leave, and then, you know, so they really intended to leave, and then they sat down, or could, like I said, they could just have they want a paper cup of coffee because they're going to leave with it after they drink half of it and leave. So you usually don't see that high of a percentage of people that say to go and then sit down, but it's not an issue at this time.
Okay, thank you.
I think in doing the observation test, just to clarify, the reason they didn't listen to what the customer said was because they didn't think it was important. They didn't care what the customer said. All they cared about was whether the customer sat down, and that's based on their understanding of how the board policy should have been implemented, and it's simply not. It's simply not true. The second thing I wanted to mention was that, you know, they performed the litmus test. They took the 4 observation test results and they compared them with 6 months of sales and saw where the observation test fell within the range of sales for those 6 months. It's interesting to note that not one of those 4 observation tests fell within the 6 months that they used for the litmus test. So, for instance, they tested, one of the days was August 2010. Well, that wasn't in the 6 months. March of 2011 wasn't in the 6 months. October 2010 wasn't in the 6 months. And March of 2011 also was not in the 6 months. So they're using the 6-month recorded taxable sales range as the litmus test, and they say, well, that range was from 2% approximately to 27%, and one of the observation tests fell within that range, but then the other test fell at the upper end of that range. And I'm just pointing out that the observation tests weren't even for the same months that 6-month test. So are we really comparing apples to apples again? And then if we did expand it, would the range be, if both of the observation tests fell within that range, would we then just accept the taxpayer's recorded percentage, or would we still be averaging the 2 observation tests and applying those to total sales? And if so, what's the rationale?
Question Department, when was the audit concluded?
Concluded as, what was the, well, I'd have-
Finalized the audit, you sent the letter?
Oh, well, I have to,
2013?
And while he's researching the question of the appellate, did the appellant perform a test of their own? And that you have a test that you've conducted that you'd like to recommend? The reported amount, as I understand it, is 10% of the sales are taxable. Not to dispute whether that's true or not, but
We believe we're doing it right. I mean, we're asking the customers whether it's for here or to go, and we're ringing the coffee up. And there's no incentive for the barista to incorrectly hit the wrong key, especially considering if they do hit the wrong key, it's going to make the coffee incorrectly, and they're going to have to remake it. So there's more incentive for them to hit the right key and to make the coffee the way they want, the way the customer wants it, which is for here or to go. And we have done that. I mean, the test is the recorded, what we've keyed into the register, because based on the customer's desire and wishes and statements, which is kind of goes to why we didn't want another observation test, because we believe we're doing it correctly to begin with.
late 2011 is when the audit was completed.
okay. In reference to the tablecloth test, how many chairs and all that stuff. What cost you to go in and do an observation test?
What caused us to do that?
Department, my apologies.
The auditor?
Yeah.
The auditor, the number of people that were sitting down. When you go in there, if you go online and look at Yelp, it'll say that it's a very busy, the one in Healdsburg is very busy. It's a lot of people that don't need to get to work, or people that are on vacation. It's
Okay.
an area that it was more than 11% that they're in their estimation.
And let me encourage the department, when the department comes before the board and provides us with data where they're basically saying that it was 108 transactions in this case that were taxable, you only picked up 81. The same way you have to justify when you pick up more, when you actually don't adjust and you give the benefit of the doubt from your perspective, you have to justify that, because the determination of whether you gave the benefit of the doubt can't be entered into this as something to consider in the determination. I mean, in this case, I get it that it was an observation test. 108 people were observed to have sat down. You only disallowed 81, allowing 20 plus, even though they sat down. For whatever reason, you shouldn't do that unless you're prepared to come in and say you gave the taxpayer the benefit of doubt for a specific reason. Otherwise, your test should reflect what actually happened. But just an encouragement, you guys continue. I mean, I'm with giving the taxpayer the benefit of doubt. When I was an auditor or supervisor, one of the things I used to tell my team members is that these are all estimates. And I liken it to baseball. And I said, listen, our goal is not to hit a home run. Our goal at best is to get the first base. We don't need to get the second, third, and knock a home run. These are just estimates. The objective here is to assist the taxpayer in complying subsequently, prospectively, once we've gone in. It's somewhat of an education, which ends up with a tax liability, because even first base, as it appears to be in this case, maybe somewhere between first and second, is still a liability. Anyway, further discussion, members?
Move to take it under submission.
Member Harkey moves to take it under submission, second by Member Stovall. Without objection, members, such will be the order.